Terry Jarrett, and I am the General Counsel for MPUA. Happy to be with you this morning, and I am going to be giving a presentation on the ins and outs of the Missouri Sunshine Law. Of course, the Missouri Sunshine Law is a very important law for public entities, of which we all are a part of. So it's always good if you don't know about the Sunshine Law to learn about it, and even if you have experience with it, it's always good to get a refresher so that you keep up to date on the current Missouri Sunshine Law. So let's get started. First of all, the entire law is based on a public policy for openness. It's the public policy of this state that all meetings, records, votes, actions, and deliberations of public governmental bodies must be open to the public unless otherwise provided by law. And those sections in the Sunshine Law, sections 610.010 to 610.200, shall be liberally construed and their exceptions strictly construed to promote this public policy. And what that means is that in order to have a closed record or a closed meeting, you have to have a specific statutory provision that allows for that closure. So if there's ever any doubt about that, the public policy is for openness. And that's the way a court of law is going to look at the law. If there's ever a question about a public record or a public meeting, the assumption is it's open unless there is a specific statutory provision that closes either the meeting or the record. So first of all, let's talk a little bit about public governmental bodies. What are they? Well, a public governmental body is any legislative, administrative, or governmental entity created by the Missouri Constitution or Missouri statutes, or by order or ordinance of any political subdivision or district. So any sort of municipality, county, state government, agency, or body is going to be considered a public governmental body. Now, there are some issues about that. It's very difficult sometimes to determine what is a public governmental body. You have ambulance districts, you have water districts, you have, all kinds of different kinds of library districts. So, sometimes could be a little difficult to determine whether or not you have a public governmental body, and so you would have to actually go to the statutes and try to determine that. Now, there's also a wrinkle in the law. There's what's called a quasi-governmental body, so it's not as cut and dried as it might sound. Quasi-governmental body are persons or corporations whose primary purpose is to enter into contracts with public governmental bodies or perform certain governmental functions. For example, there is a case out there that says that a city-operated hospital would be a governmental body. So again, if you're in doubt, you may want to check your statutes or check with your city attorney to determine if a certain board or certain entity in your city is actually would be considered a public governmental body or a quasi-governmental body. Also, subcommittees. We all, probably all of us have certain subcommittees certainly here at MPUA, we have, like with our power pools, for example, we have the MOPEP, SWIMPEP, and MPEP committees. We have other various committees, the MISO and SPPRTO committees, for example. I'm sure your cities have, committees. You have zoning commissions, you have various sub-entities of the city. Those would also be considered public governmental bodies. And the key here is that these entities are either do actual public governmental work, or they have been created for the specific purpose of recommending directly to the public governmental body's governing board or its chief administrative officer policy or policy revisions or expenditures of public funds. So what we're really talking about here is if you have any of those sub-entities that are discussing public policy or changes to public policy, or if they're talking about how to expend public funds, then they would fall under the Sunshine Law, and you would have to follow all the requirements of the law. Let's take a look at MPUA's entities. Not all of our entities are considered public governmental bodies. The MPUA Board of Directors was created by an interlocal agreement, which is governed by Chapter 70 of the Missouri statutes, and it would be considered a governmental entity. It was created by MUJMUC, the Gas Commission, MAMU, the RSC. So all of these entities, most of them are considered governmental entities. But anyway, the MPUA Board of Directors would be considered a governmental entity. So MUJMUC and the Gas Commission, they are created as joint municipal action agencies under Chapter 393 of the statutes. So they are definitely considered governmental entities, and the Sunshine Law would apply to them. Now, MAMU is a Missouri not-for-profit corporation. It was not created by a specific statute like MUJMUC or the Gas Commission. So it would be considered, and we consider it, a non-governmental entity. So the Sunshine Law does not apply. Same goes for the MPUA Resource Services Corporation. It is also a Missouri not-for-profit corporation, and so it is considered to be a non-governmental entity, and the Sunshine Law does not apply. Now, you might ask, what about the quasi-governmental entity designation? Would it apply to MAMU and the RSC? That's a good question. It has never been decided by a court. So our position is that since it wasn't created specifically by a statute, they are registered as not-for-profit corporations with the Missouri Secretary of State. And so we would consider them private corporations and not under the Sunshine Law. Now, that doesn't mean somebody couldn't sue and try to argue that we were a quasi-governmental body. But until we have a court tell us that, we take the position that MAMU and the RSC are private and not subject to the Sunshine Law. Next, let's move on to responding to open records requests. This is something that is, I'm sure, very common for all of our cities, and certainly for MPUA. We get open records requests quite frequently and have to respond to them. So let's take a look at what the requirements are under the law when it comes to responding to these open records requests. Basically, the law allows requesters to submit open records requests in multiple formats. Many public governmental bodies have an official request form that they either have them in print or on their website that folks can fill those out and send them in to request open records. It can be done written, either by letter or by email or any other text, whatever type of media that you're going to use. Or it can also be verbal, just they can come in person and ask for it, or by a phone call. A tip for you would be if someone does call uh, either on the phone or come in person and ask verbally, to make some sort of writing, have them either fill out a form that you have, or you can just jot it down and what they ask for, the date and time they ask for it, and how you responded to that, so that you have a record memorializing that. I mean, what you don't want is somebody coming in and getting a record and then a year later come back and say, you never responded to my sunshine law request, and there's no written record, indicating that you have. So always good to document that some way. Custodian of records. This is also a law requirement. The governmental body must appoint a custodian of records who is basically in charge of the official records for the entity, and the identity and location of a public governmental body's custodian has to be made available upon request. At MPUA, our custodian of records is Amy Aarons, and that's posted on our website. So the public knows that Amy is our custodian of records, and that's where requests need to be made is to Amy. However, you have to be careful, because if someone comes in and asks for a record or submits a written record to somebody who's in the organization who's not who is not the custodian of records, that does not necessarily mean you don't have to respond to the records request. So you need to tell any of your employees who do any interactions with the public, that if you do get some sort of request for records, please refer that person to the custodian of records, so that the ball isn't dropped and all of a sudden you get a lawsuit from someone claiming they didn't respond to an open records request. So just make sure that you have the open communication with your employees to make sure that that gets to the right place. Now, what's a public record? That can be tricky as well. Any record, whether written or electronically stored, retained by or of any public governmental body, including any report, survey, memorandum, or other document or study prepared for the public governmental body by a consultant or other professional service, paid for in whole or in part by public funds, including records created or maintained by private contractors under an agreement with a public governmental body on or behalf of a public governmental body. Pretty broad definition. And again, the law always leans toward openness. So it's always good to take a look and basically have an open mind as to what is a public governmental body, a public governmental record. But anyway, let's go next to what is not a public record. And there is a definition of what's not a public record in the statutes. The term public record shall not include any internal memorandum or letter received or prepared by or on behalf of a member of a public governmental body, consisting of advice, opinions, and recommendations in connection with the deliberative decision-making process of said body, unless such records are retained by the public governmental body or presented at a public meeting. And so I know here at MPUA, a lot of times I will prepare legal memorandums. Of course, they're protected under a section of the Sunshine Law for legal advice and those types of things. But other memos are created by non-lawyers that are not necessarily secret, but they may just have advice, opinions, recommendations to the deliberative decision-making process of a public governmental body. And as long as those memos are not retained, that is, they're destroyed after the business is conducted by the public governmental body, then that would not be considered a public record. However, if it's retained and somebody has an open records request that would fall that this memo would be responsive to, you would have to disclose it because it would be a public governmental body since it was retained. So, another thing that would be considered not a public record is drafts of memos or documents. For example, I prepare resolutions from time to time for MPUA or MUJMUC or MAMU. And we'll go through several drafts before we get a final document. Those prior drafts would be considered to be not public records as long as they're not retained. So all you really need to do is keep the final copy, which is the public record that, say, your city council would vote on. And as long as you don't retain those drafts when the resolution is finalized, then it's not considered a public record, and you don't have to keep it. But again, if you do keep it and people ask for that, then you're going to have to disclose it, because if it's retained, it does remain a public record. Also, electronics, things that are electronic are also considered public records. There was a debate early on when email first came about, whether or not emails were considered public records because they were not in paper. The courts have pretty much said no, the electronics are considered to be public records if it's electronic form. And the law has actually been changed to provide for that. So it may be considered a public record if it is sent to a quorum of officials, and this includes the sender, and it relates to public business. And we'll talk about what quorum is and what quorum means in a little bit. But if you are emailing as a quorum of a body, say your city council is emailing, and on the email chain, it's a quorum, that is considered a public document, and it's also considered a public meeting, which means you have to comply with the Sunshine Law. And we'll talk a little bit about that again in a little bit. So if the message meets all of these requirements, then a copy of that message or the email chain should be sent to the custodian of records, because it would be considered a public record. Responding to records requests. Again, there's requirements on the timing and the delivery of responses to open records requests. There is a statutory requirement for the governmental body to respond to any public records request from the public. The body must act on the request as soon as possible, no later than 3 days after the request was received by the custodian of records. And this is exclusive of weekends and holidays. So it's basically 3 business days to respond. Now, that doesn't mean you have to provide the records in 3 days. That just means you have to respond to the sender by 3 days. It's perfectly fine to send a letter or an email or however you respond saying, we're going to need more time to put together your records request. You're asking for multiple documents. It's going to take time to search and find those for you. So you need to say it's going to take us a week, or it's going to take us 2 weeks to respond. Sometimes agencies get requests that are for hundreds or even thousands of pages. So in those instances, it might take weeks in order to search and find records. Someone might be asking for records that are 20, 30, 40 years old, and someone's going to have to go down to the basement of the city hall and go through your archives to try to find records. So you don't have to get it done in 3 days, but you do have to let the person know within 3 days that, hey, it's going to take us longer than 3 days to get your documents together. So again, practical tips. It's always good to put things in writing. So contact the requester in writing so that both parties have a copy of the response. You want to include the date and that the response was sent, confirm the records that were requested, address any possible fees that might be applicable for searching and copying, and also confirm the way the records will be provided. You can either provide them paper copies. A lot of times, if somebody wants to provide you with a jump drive or something, you can put it on their jump drive for them. Or you basically, you can email it to them as well, PDF everything and email it. There's no right answer there, just whatever works for everyone. But you do want to confirm that that's the way the records will be sent on your response. And again, if you can't produce those records within 3 days, you still need to contact the requester within the 3-day time frame and give them an estimate on when you can provide those documents. And again, to do that, you want to, of course, do that again in writing. Let them know they can't be produced within 3 days. Estimate the date when the request can be fulfilled, and also put the reason. Again, it's going to take time to search. The records are voluminous, and it's going to take time to put them together, and so forth. Sometimes some of the records may be sensitive records, and you need your attorney to review them to make sure which records are able to be produced and which records are closed. So if there's ever a doubt about that, you can take the time and let people know that, well, we have to have our attorney review it because some of the things you've asked for may be closed records. And again, put those reasons in that letter so that there's a record of that. And even if you have no records that are responsive, you still have to respond. So if you don't have any records after somebody asks for certain records, you still need to send them a response saying, got your open records request. However, we don't have any documents that are responsive to your request. And we consider, this matter closed. And this is also an important concept for you to remember. A lot of times you're going to have information that someone is asking for, but it may not be in a specific document. It may be in parts of it in one document, parts of it in another document, parts of it you may have, but it's not in any document. You're not required to create a specific document to respond. Now, a lot of times it may be real easy to just create a document and give it to them. And you can certainly do that, but you're not required to do that. I can imagine sometimes someone will come in and it would take quite an effort to create a document, of the information they're asking for. And certainly if it's too onerous, you don't have to make the effort to do that. And if you have a policy where you're just not going to do that ever, that's fine too. You're not required to under the law to make up a document. And the Jones versus Jackson County Circuit Court case stands for that proposition. Closed records. This is very important to understand what records are open, what records are closed, because if records are closed, you do not have to disclose them under an open records request. So, except to the extent disclosure is otherwise required by law, a public governmental body is authorized to close meetings, records, and votes to the extent that they relate to certain statutory exceptions. And there are 26 separate reasons in the statutes to close meetings within section 610.021. Some of the common closed record authorizations include legal. All of your legal discussions or documents are normally considered closed records, and so you can close them and not have to disclose. Real estate transactions. When you're going through, say, purchasing land or selling land as a public governmental body, while you're going through those negotiations and finalizing the sale, those records are considered closed. Now, after the transaction has been completed, those records may be opened up because, you're not really protecting anything anymore. But while you're going through that process, those records are closed. Hiring, firing, discipline, or promoting, all kinds of personnel decisions that you make, those are closed. Not, mainly really to protect the personnel, people, but also the body itself. So those are considered closed. For schools, scholastic records are considered closed. Somebody couldn't dial in and get or call in or write in and get student records unless the parents or the student approves. A lot of times, for example, if a student is applying to a college, they'll sign some sort of authorization to a school to allow that school to release that student's records to the university for admissions purposes and that kind of thing. When you do a bid process, an RFP or competitive bidding process, you can keep those bid documents and responses closed again until the bid has been awarded, and then some of that information will become an open record. But when you're in that process, those are considered closed. Personnel records generally are all considered closed as well, not just the decisions that you're making. You can have closed meetings to discuss those, but all of the records that come out of that and all other personal records are also considered closed as well. Auditor records, I'm sure all of you cities have auditors or have been audited. Those records are also considered closed. And there are lots of other closed records. As I said, there's 26 of them in the statutes. And then there's also another way other than those 26 to close. It's when other laws call for closed records, then you can close them also under the Sunshine Law. So these are other records which are protected from disclosure by law. So this cannot be used as just a standalone exception. You have to use this in conjunction with other laws. For example, HIPAA is a big one. This is the health one. Trade secrets is another one. Missouri has a trade secrets law. And so if you have any trade secrets that you're discussing, trade secrets is defined pretty broadly. So, even when you're discussing strategies and you're discussing, certain processes, you might be able to claim those are trade secrets, and those are protected from disclosure by the trade secrets law. So under that law, you could close them under the Sunshine Law. And this is a fairly new, just a couple of years ago, this specific exception was put into the Sunshine Law. And this is municipal utility information that can be closed. Individually identifiable customer usage and billing records for customers of a municipally owned utility, unless the records are requested by the customer or authorized for release by the customers, except that a municipally owned utility shall make available to the public the customer's name, billing address, location of service, and dates of service provided for any commercial service account. So basically for residential customers, their information is considered closed unless they provide an authorization to release that. I think it's probably, you see this some with like some solar developers contacted, one of your retail customers and wants to sell them solar panels. And so they come to the city utility and say, release their, usage records to us, and, at that point, you could tell them, well, we need an authorization from the customer. And I know a lot of the cities do have actual forms they've created, for customers to actually fill out to do that sort of thing. So you need to make sure you have that written authorization from the customer before you would release that for the residential customer. Now, for a commercial customer, you can provide the customer's name, billing address, location of service, and dates of service. In order to provide the usage, you would have to get the customer's authorization to do that. Closed records. If someone requests a record that turns out to be closed, then you would need to provide the requester with the reason for the closure and cite to that specific provision of law that you were relying on to close it. And that's, you would just say pursuant to section 610.021.22, for example, whatever one that you are relying on. So when you get a request, you probably will have some open records that you will provide, but then you will say, well, for these records, they're closed pursuant to here. We can't disclose those. Now, the law does require in your response for a closed record to at least describe generally the material exempted, unless that would reveal the contents of the exempt information. You can basically, for example, say if it's some legal document, and it contains legal advice, you can say this is a document that contains legal advice to, to the city council, and we can't disclose it. Something along those lines. If the records responsive to the request contain closed information, the body will be required to separate the exempt and non-exempt material. Redaction. So if you can redact the document, redact all the closed information out of it, you can, send the document over. The rest of it's open. You can do that, and you're required to do that. If redacting it is going to render it, pretty much, you see a lot of documents sometimes where there's maybe one word or two words in the whole document that's not, leave the these and the a's and the ands in it, and everything else is closed. But you wouldn't be required. You could just close the whole thing at that point. But if there's just a small amount of closed information in those documents, then you can redact it and provide that to the person. Fees you can charge for work you do to provide the response to an open records request. Those include duplication costs. You can charge fees. Normally, a body can charge 10 cents a page for copying. That's paper that's legal size or smaller. If it's larger, you say like photos, maps, those types of things, then you can charge the exact cost for duplicating those. Also, your fees must be the lowest amount for search, research, and duplication time. So, for example, if it's a simple records request, you would have, the person that makes the lowest salary is going to be and it's simple to do. That would be the person who's you would charge out for doing that. If, for example, they're requesting documents that may be legal in nature and you have to have your attorney review those, then you can charge the attorney's time for that as well. But it has to be the lowest charge. You can't, you couldn't get your highest paid employee, to do a simple records request and charge that employee. You have to make sure it fits the importance and the time needed to do the research and duplication. Sunshine Law policy. All public governmental entities have to have a written policy that's in compliance with the Sunshine Law. And this policy has to be open to inspection regarding the release of information on any meeting, record, or vote. So if you don't have a policy, the Attorney General's office, if you get on the Missouri Attorney General's website, it is a great resource for Sunshine Law materials. There is a handbook there you can download. They have forms you can download, whether it be request forms for people that want to request them. I believe there is a Sunshine Law policy form template on the website as well that you can use. MPUA has a policy. It's on our website that you can take a look at. So if you don't have one, I would urge you to put together one as soon as you can. All right, we're at the question stage, but before I go into that, I did want to talk a little bit about open meetings. I wanted to cover the open records portion of this in my slides because that's very important. And that's where a lot of folks run afoul of the Sunshine Law by not responding properly to those requests. However, it's also important to remember that the Sunshine Law applies to meetings, such as our city council meetings or committee meetings. of your, your board, utility boards, those of you cities that have those are considered public governmental bodies and need to follow the requirements of the Sunshine Law. So under the Sunshine Law for meetings, you have to have public notice and an agenda. So the Sunshine Law requires that a public governmental body must provide at least 24 hours notice before a meeting. And this public notice content must include the time, date, place, and a tentative agenda for the meeting. And it has to be posted in a public place. We post our public meetings here at MPUA on our website. You can do that as well. Others post them, they'll put them on the front window of the city hall or wherever you post your public notices. That's where you need to post that. Now there is an emergency exception of that 24 hours notice if it's done for an emergency. But still, even if it's for an emergency and it's less than 24 hours, notice must be posted as soon as possible. So if you find out 4 hours before that, hey, we're going to have a meeting because we're going to have a meeting after this afternoon because of an emergency. As soon as you know it, post it on wherever you post your notices. Now, sometimes meetings can be conducted electronically, either by phone, by Teams, Zoom. So those are still considered public meetings, just like in-person meetings are. So, if you're going to do that, you have to make arrangements for the public to participate in those as well. So you have to provide a link to your Teams meeting so that the public can watch it, or Zoom, or whatever media you use, so that it can be accessed by the public. And again, the note is posted online, posted at your meeting locations, wherever you post your meeting notices, and it can be done in multiple locations. And again, meetings must be considered open, and they have to be open to the public unless there is a specific exception that allows for the closure, same as a record. And again, the public can attend, and they can also record a public meeting. So if somebody comes with their tape recorder, you have to allow them to tape the meeting. That's required by the law. Minutes, written minutes must be taken for all meetings, both open meetings and closed meetings, and include the date, the time, the place, the members that are present or absent, and a record of all the votes. Again, votes taken at a meeting must be recorded in the minutes, attributing roll call votes to individual members. Now, that doesn't necessarily mean you have to take all votes by roll call. You can certainly do, by acclamation, or by just, all those in favor say aye, all those opposed. You can do that. But when you're required to take votes by roll call, you have to record that roll call vote in your meeting minutes. Closed meetings. You can have closed meetings for the same reasons that you close records. When you're going to discuss legal issues or real estate transactions, or personnel issues, you can close your meetings. But you have to take a vote in open meeting to close those records, and you have to put it in your agenda that you may have a closed session due to personnel or legal or whatever reasons that you're going to close the meeting. And then you have to, in your motion to close, please note the specific legal provision that the closure is based upon in your meeting minutes. And so again, meetings can be closed in limited circumstances, but again, those exceptions are going to be strictly construed. And if you take a vote in closed meeting, again, you need to record that in the you need to have closed minutes, and you need to record that vote in those closed minutes. So, you can keep those closed records closed, but you do have to keep them. And they have to follow the same format that an open meeting minutes would be conducted with. So that is my presentation for today on the Sunshine Law. As you see on my last slide here, that is my contact information. Please feel free to contact me anytime if you have any questions or want to discuss Sunshine Law issues. I'm happy to do that. And if I can't answer your question, I'll certainly try to point you in the right direction to where you can get your answer. So I hope you've enjoyed the presentation today. I hope you've learned a lot, and I wish you good luck and take care.